The Honorables, the presiding Chief Judge and Judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Good morning and welcome to the North Carolina Court of Appeals by WebEx, our virtual courtroom here. And your panel today is, I'm Judge Donna Stroud as head of the panel. We also have Judge Valerie Zachary and Judge John Tyson as our other judges on the panel today. We have one case for argument, State of North Carolina versus O.C. Billings. And I believe that the appellant is ready to proceed.
Yes, Your Honor. Good morning. May it please the court, Jim Grant with the Office of the Appellate Defender on behalf of Mr. Billings. I'd like to reserve 5 minutes of my time for rebuttal. Your Honors, Mr. Billings was originally placed on satellite-based monitoring in 2009. And as the court is aware, in 2019, our Supreme Court in Grady 3 enjoined enforcement of the satellite-based monitoring regime against all offenders in the so-called Grady class. That is to say, individuals who were ordered to SBM on the grounds that they are recidivist under the statute and who are not under any sort of post-release supervision or other type of sentence. It's undisputed that Mr. Billings falls within the Grady class. So given the unambiguous injunction of our Supreme Court in Grady 3, the state should have removed him from satellite-based monitoring in 2019. Instead, the state conducted the ad hoc rehearing at issue in this case, and the trial court ordered Mr. Billings to remain on SBM indefinitely. There were at least 4 problems with this procedure. First, the court lacked any statutory subject matter jurisdiction to conduct a rehearing. Second, even if there was jurisdiction to conduct a rehearing, the state failed to meet its burden of demonstrating that continued SBM was a reasonable Fourth Amendment search under well-established precedent from this court, as it has failed to do, frankly, in almost all of the cases that have come before this court over the last several years. Third, even assuming jurisdiction and a sufficient evidentiary showing, the trial court exceeded the statutory authority by ordering a period of continued SBM that amounts to a lifetime order. And finally, the trial court erred in denying Mr. Billings his statutory right to the assistance of counsel. And so for these reasons, we would ask that the court vacate or reverse the SBM order without remand in this case. Turning first to the jurisdictional issue, nothing in Grady, the SBM statutes, or this court's precedent permits a rehearing of the sort that was conducted in this case. You have 2 statutes which permit an SBM hearing. One is 14208.40a, which discusses SBM in a sentencing hearing, and the other is 14208-4.40b, which allows for what's called a bringback hearing. And I want to quote from the statute: a bringback hearing is appropriate when, quote, when offender is convicted of a reportable conviction and there has been no determination by a court as to whether the offender shall be required to enroll in satellite-based monitoring. In this case, there was already a determination about Mr. Billings' eligibility for SBM back in 2009, so the state can invoke 208.40b as a statutory grounds to have this hearing. In fact, this court has recognized that these sorts of hearings are inappropriate in the Clayton case.
Excuse me, Mr. Grant. I'm well familiar with the Clayton case. Do you agree that the trial court would have had subject matter jurisdiction if the state had filed a 60B motion?
Well, so that's what the that's basically the state's justification here, that there was some sort of implied Rule 60B motion. Now, I am not aware of any case where the court has explicitly held that Rule 60B is an appropriate vehicle for the state to obtain a rehearing in these sorts of cases. But let's just assume, for the sake of argument, that a 60B motion is appropriate hypothetically. The state simply didn't make a Rule 60B motion in this case. It filed no motion. It didn't make an oral 60B motion at the hearing. It didn't even really imply that it was making a Rule 60B motion. And I would direct the court's attention to the Turner case, which we've appended to the reply brief. In candor, that is an unpublished case, but I think it remains instructive. In Turner, this court pointed out just that the state didn't make a motion under Rule 60B or any other conceivable vehicle to conduct a rehearing. So I think our position, Judge Zachary, would be that the question of whether a Rule 60B motion is an appropriate vehicle for the court, for the state to obtain a rehearing is an unsettled question. But even if it were, the state simply didn't make that motion in this case.
Did the state file the notice to the defendant?
No, there is no notice in the record like there would be in a first instance, or should be at least in a first instance SBM hearing. What the state essentially did, Judge Zachary, is use its calendaring authority to simply haul Mr. Billings back in front of a judge. And this court has already rejected that sort of procedure in the similar context of sex offense registration. Direct the court's attention to the Timberlake decision. In Timberlake, you had a petitioner who applied for removal of his sex offender registration requirement, and the trial court, without objection from the state, terminated his registration. The state subsequently became dissatisfied with that result, and then basically just without filing a motion similar to what happened in this case, just kind of brought the defendant, or rather the petitioner in that case, back for a rehearing. And this court in Timberlake said that that was inappropriate and there was no jurisdiction to have a hearing. There's got to be something invoking the jurisdiction of the court. The state can't simply use its inherent calendaring authority to just bring a defendant or a petitioner or whoever back into court whenever it is dissatisfied with the result of a proceeding.
But do you agree that since the Supreme Court only declared one portion of the statute unconstitutional, that you could have another satellite-based monitoring hearing and impose satellite-based monitoring on other constitutional grounds?
Again, Your Honor, I don't think that under the statutes as they exist that is permissible. I don't think the state can use a Rule 60B motion as a sort of grand reservoir of authority to just get the result it wants. The SBM is a creature of statute, and we have two statutes that provide for scenarios where an SBM hearing can be conducted, and neither of those situations apply in this case.
Mr. Grant, are you familiar with the concept of motion in the cause?
I'm sorry, say that again, Judge Tyson, I didn't hear you.
Are you familiar with the procedure of motion in the cause?
A motion for cause?
Motion in the cause.
Oh, motion in the cause. No, be frank, Judge Tyson, I'm not familiar with that.
So if a court has jurisdiction and there are matters within the original case that need to be brought back, doesn't the court have the authority to revisit the case that's already within its jurisdiction?
Well, I guess my response to that, Judge Tyson, would be is that the trial court lacked any jurisdiction in this case in the first instance. Once the monitoring order was entered in 2009, that's the end of the case.
And you're saying the court has no authority to alter or amend that?
I think that would be our position, Judge Tyson, but let's assume.
Are you also saying that if we would agree with you on Grady, on the application of Grady, the state has no recourse to revisit any of these folks that were properly sentenced under the statute? Is that your argument as well?
I think that is the argument, Judge Tyson, and also in a Rule 60B, at least for Rule 60B, which I am a little bit familiar with, Rule 60B is a motion filed by an individual or a party seeking redress from the judge. I mean, the state got what it wanted in 2009. It just so happens that subsequently we all discovered that that was an unconstitutional application of the statute.
In part.
Or at least as applied in this case.
Well, going back to Judge Zachary's question, if the court has jurisdiction, but you're not challenging that, and the court has the ability to revisit or amend its own orders, I don't even think that a Rule 60 motion would even be required anyway. The court could do it within the authority to amend or correct its own orders as a motion to cause.
I mean, I'm unfamiliar with any case where a trial court has been permitted to amend an order or a judgment that was entered a decade ago. There has to be some limiting principle, I would think. Now, let's assume for the sake of argument
Let me ask you this, if a death penalty is set aside, you don't think that the court would have the authority to reconvene a hearing to impose life without parole?
Well, those hearings are specifically provided for by the remand order of the superior of the appellate court, the Supreme Court. You know, if the Supreme Court had ordered a remand for a new hearing, well, then there's a new hearing because the court has ordered one.
Well, Grady is silent on that, is it not? It didn't say you couldn't do it.
That's true. Grady also didn't say it should. And theoretically, if you look at the Grady decision, I think Justice Newby in his dissent points out that perhaps Torrey Grady was eligible under another lifetime grounds because his offenses were aggravated offenses. And if they weren't, they were surely involving the physical, mental, or sexual abuse of a minor. But yet the majority in Grady didn't remand for a new hearing on potential different grounds, even though the dissent raised that issue. The Grady court just reversed the order outright. It seems to me that if the Supreme Court was of the opinion that you could have a rehearing to revisit components of the statute, that it would have said in the majority opinion that they were remanding for a determination of satellite-based monitoring on other grounds. Now, I think part of the reason why maybe the Grady court didn't do that is because the same issue in Grady abides in this case, which is that let's assume for the sake of argument that there's jurisdiction to have a rehearing under Rule 60B or a motion in the cause or whatever vehicle might provide the court jurisdiction to conduct a hearing. The state in this case utterly failed to meet its evidentiary burden under well-settled case law, not just Grady 3 and the cases that have followed it, but cases stretching back all the way to 2016 and 2017, State versus Blue, State versus Morris, State versus Green, all of which are good law, none of which were appealed by the state, all of which were binding on the trial court. You know, the state at this hearing called no witnesses, it presented no evidence. Therefore, the trial court had nothing before it to evaluate the two factors it has to consider at a Grady hearing, which is on the one hand, the nature of the SBM search, and on the other hand, the efficacy of that search towards accomplishing a legitimate government interest. You know, the case law is very clear that this requires a reversal without remand, as it has, again, in nearly every case that's come before the court. And in its brief, the state addresses this problem by simply ignoring binding case law from our courts. Green, in fact, is not cited at all in its brief. In fact, other than our Supreme Court's Grady decisions, the state doesn't cite any relevant SBM cases decided after the United States Supreme Court decided its Grady case in 2015.
So Mr. Grant, are you saying that that the state has no recourse? So with everyone that fell within the recidivist class that was addressed in Grady 3, the state can't go back and revisit those cases and determine, first of all, if they are in the class and they need to have the satellite-based monitoring terminated because it's unconstitutional, and then also are either at that same hearing or at a different hearing, determine whether or not they ought to be enrolled in satellite-based monitoring on account of other factors, not solely because of being a recidivist.
Again, I think that's our position, Judge Zachary, and I think that's bolstered by the way the Supreme Court handled Torrey Grady's case. But again, I think I'm willing to, at least for the sake of argument, concede that maybe there was some procedure that may have been available to the trial court. Again, the state didn't make any of these motions. Had it made those motions, maybe there would be jurisdiction. And if there were jurisdiction, at the end of the day, the result in this case has to be the same, because even if there was jurisdiction, the state failed to meet its burden in this case. And the state's brief, frankly, just ignores the 6 years of case law we've had about the nature of the state's burden and what happens when it fails to meet it. You know, it seems the only thing the state has to say on this point is that, it cherry picks one line from the Grady decision that talks about the lack of an individualized hearing and turns that into the entire thrust of the Grady decision, but that's just one of several problems that the court identified with SBM. And it totally ignores the language in Grady 3 that talks about the state's burden, which basically affirms implicitly this court's decisions in Blue and Morris and Green and all of those cases that followed.
Mr. Grant, if I could, so it seems even if there were a way for the court to have, a rehearing of this nature, so where the state didn't file any sort of motion, which also kind of gets into the no counsel issue, which I know is one of your other issues, just bringing someone back in with no attorney and with no motion. I'm having trouble, just seeing, how the state can just bring people back in just because they're on a calendar. So, I mean, there was just absolutely no notice of anything to Mr. Billings other than you're on a calendar?
So the record contains no notice. At the risk of going outside the record, I think Mr. Billings did receive the sort of full standard form notice that anyone with a court appearance receives.
Right.
Like the ACES printout basically that says you're to appear at this time, but they did not file the form notice that we're accustomed to in these cases. And there was no other pleading or motion, oral, written, or otherwise.
What, was he served by certified mail as required by the statute for a bringback hearing?
I can't speak to that, Judge Zachary. I don't know.
I didn't see anything in the record. Do you know of anything in the record showing?
No, I don't know of anything either in the record or outside of the record that would suggest he was served by certified mail, but I can't say that he wasn't. I just don't know, Your Honor. I'm sorry. So again, just on this point about failing to meet the burden, the state's brief in ignoring this case law just basically invites trial courts to similarly ignore this court's precedent. And it seems pretty clear.
I'm sorry to keep interrupting you.
No, it's fine.
I just want to make sure we're clear on this. The Supreme Court only declared one portion of the satellite-based monitoring statutory regime to be unconstitutional.
You
agree with me on that?
Yes, the Supreme Court declared essentially facially unconstitutional one category of lifetime satellite-based monitoring.
So it's possible that your client could have qualified for satellite-based monitoring for other reasons.
As a statutory matter, yes, Your Honor.
Yes. Okay.
Again, where the state has a hearing and fails to present any evidence, the law is very unambiguous that can't support an SBM order.
I understand your argument.
And so for that reason, we've asked the court to reverse the SBM order. It does bring me at this point to the issue of the conditional petition for writ of certiorari we filed. I think it is our position that regardless of what this court does with the order before it, that order superseded the 2009 order. And so that 2009 order is essentially void. At an abundance of caution, we've filed the conditional PWC basically to provide this court a vehicle to address the 2009 order in the event it concludes it still has some import. The 2009 order is plainly unconstitutional under Grady 3. I don't think the state even really disputes that. So if the court is inclined to believe that the 2009 order would remain in place somehow, we have filed the petition for writ of certiorari to allow this court to address the 2009 order and hold it unconstitutional in light of Grady 3. I'd just like to briefly address the third and fourth issues. Even assuming if there was jurisdiction, which again, our position is there wasn't, even assuming that there was a proper evidentiary showing, which again, there wasn't, there's no statutory authorization to order a defendant to indefinite SBM. This order is unlike any that I've ever seen in one of these cases. The order just says the defendant shall remain on SBM. There's no temporal limitation at all to that order. So in effect, it's another lifetime order. We know Mr. Billings can't be ordered as a recidivist because of Grady 3. His offense doesn't fall within any of the lifetime categories. So the only statutory avenue available to the trial court, again, assuming a proper hearing, would be to order SBM for a period of time, a discrete period of time. Indefinite is not a discrete period of time. I know the state argues in its brief that for life is in essence a period of time. This court rejected that argument a decade ago in State v. Singleton and State v. Cowan, both of which are cited in our briefing. And so for that reason, the trial court exceeded the scope of its statutory authority in addition to the jurisdictional and constitutional problems we've presented. And lastly, I think the court has noted that Mr. Billings was denied his statutory right to counsel. Both NCGS 7A 451A18 and 14208.40B say that an indigent defendant is entitled to counsel at an SBM hearing. So at minimum, therefore, this court should remand for a new hearing at which Mr. Billings will receive his appointed counsel. Although again, given the fact that the state has failed to present any evidence of SBM's reasonableness, Green would dictate that a reversal without remand is the appropriate remedy. Unless there are additional questions from the court, I think I'll reserve the balance of my time for rebuttal.
Okay.
Thank you.
Any other questions at this time? Okay. All right. Yes.
One question, please. I'm sorry, I was muted. You would agree that there's generally no right to appointed counsel at a civil proceeding, is that correct?
Yes.
And does a client have to make an assertion of indigency in order for counsel to be appointed even in a criminal case?
Yes, Your Honor, but
Did your client assert indigency and request counsel?
the record is silent as to that. But I will say that if this, go ahead, Judge, I'm sorry, I don't mean to interrupt you.
Can we presume then that he did not assert indigency nor request counsel?
I'm not sure we can make that assumption, Your Honor, because if this is just a continuation of the 2009 case, Mr. Billings was indigent in 2009, and there's nothing that would suggest over that intervening decade that he somehow became not indigent. But I will concede that there is nothing on the record which shows that Mr. Billings affirmatively requested the appointment of counsel. And I will note that, you know, in the guidance memos that the Attorney General and the Conference of District Attorneys have been collaborating on, which is part of the record on appeal in this case, that the Attorney General's office sort of, in its memo, suggested that because these are civil proceedings, there's no right to counsel, but that directive or that position is contrary to the statutes which specifically provide for SBM hearings to have a right to appointed counsel. So I don't know if the issue of counsel didn't come up because the state was, you know, of the opinion that no counsel was required. But again, I'll concede that the record is silent as to the issue of Mr. Billings' continued indigency.
Well, Mr. Grant, didn't the DA's best practices memo deal solely with terminating defendants from satellite-based monitoring? It didn't deal with having another hearing.
Yeah, I can't get in the mind of the Attorney General's office, but
Well, I mean, it specifically states in there, you know, that it's discussing terminating people from satellite-based monitoring on the basis of Grady 3.
Yes,
fall into that recidivist class.
Yeah, I understand that's what the memo says, Judge Zachary. My point was just that I'm not sure that anyone contemplated that there would be a rehearing for the purpose of assigning SBM on other grounds. The memo is extensive in discussion of termination. I mean, our position is that the Attorney General's office should have just removed the monitor from all the individuals in the Grady class. I understand nobody wants to make the decision to remove the monitor, and so the Attorney General and the Conference of DAs wanted to have hearings in front of judges to have these orders, but the entire memo is sort of geared towards, as you know, Judge Zachary, termination of registration. Perhaps, you know, if a tree falls in the forest and no one is there to hear it make a sound, you know, if a defendant is terminated from SBM at one of these hearings, but isn't afforded counsel, does it really make a difference? You know, I think that's part of what's going on with this memo.
He's probably not going to complain at that point.
Certainly not.
Okay.
We wouldn't be here if that had happened. So, you know, I think that might be part of what's going on with respect to the memo and saying that no counsel is necessary because it's civil.
Yeah, but and because there's in the satellite-based monitoring context, generally under the statute, I mean, I can't recall any case, and correct me if I'm wrong, or somebody correct me if I'm wrong, but I can't recall any case that says a defendant has to affirmatively assert his right to counsel and go in and say, I want an attorney. And by the way, I'm indigent. I mean, that's something that the court addresses based on the statute. Is my
Right.
recollection.
Yeah, I'm also unfamiliar with any case that says that, Your Honor.
Okay. Okay.
Thank you.
Any other questions? Okay. All right. Now we will proceed with the state's argument.
Good morning. I'm Sonia Calloway Durham on behalf of the state of North Carolina. In this matter, may it please the court. This case is really about the uncertainty after the mandate of Grady 3, the mandate being that offenders who were in that limited class, being they were recidivist only, they were unsupervised, and they had lifetime satellite-based monitoring. As to that limited class, their monitoring would be unconstitutional. However, Grady does not give us any direction for the state to then remove them. The satellite-based monitoring statutes in and of themselves also do not give any direction, presumably because those statutes did not envision the evolution of the law with satellite-based monitoring and what would happen nearly 2 decades later with respect to Grady 3. So with that in mind, the state, based on its best practices memorandum, that being the Department of Public Safety and also the DAs, set in motion a process to try to comply with Grady 3. And in doing so, well, first of all, let me go back to the statutes. The statutes themselves only contemplate the offender having the authority to ask for a review before the parole commission. And in fact, the language of that statute specifically says that the parole commission shall not consider any other motions except as allowed by this statute. In other words, by this section, excuse me. In other words, it doesn't give the state the right to do it, and it's only the parole board assuming the defendant asks. So in order to comply with the mandate that these people be removed, there's that missing prong of, okay, now how do we do that? So that if the court will allow me some leeway to explain, the 3 classifications of what place someone within that prongs, rather, of what places someone within that classification, being recidivism, unsupervised monitoring, and lifetime monitoring. The one prong that became problematic was who is and is not a recidivist only. You would think it would be as simple as just looking at the court orders. The AOC forms, which were the court forms, that being the 615, which is for when you have your SVM hearing ancillary to or sometime in close proximity to your sentencing, or under the bring back provisions, which is the form 616. Those forms, just like the law on SVM, began to evolve over time. And now that the state was in a position to have to go backwards to try to identify these members, it wasn't clear just looking at the face of those documents who was and was not in the class. For that reason, it would mean to make a better assessment, you would need to go beyond just the face of the documents, perhaps going into court documents, perhaps testimony. That being said, it became necessary to have, once the state, that being the Department of Public Safety and the DAs, both coming up with lists, trying to figure out who they thought might be on the list. In fact, the memorandum gave direction to the ADAs to try to determine as best they could from the face of the documents, and I may be paraphrasing there. So with that in mind, the decision then was for the court, the original tribunal, and Judge Tyson, I think your point is well taken about a motion in the cause, although I'm not going to argue something that's not in my brief. I do agree with you that certainly would be something that would be appropriate. But we also believe that
you'd be welcome to submit a memorandum of additional authority if you want to cover that.
Yes, I would. Thank you, Your Honor. But Rule 60 also would apply, and I'll get into the specifics of Rule 60 in just a moment. But with all that having been said, the state put in process a system for trying to determine, they did not think it was, the state did not think it best for the state to have to make a unilateral decision that quite frankly required a legal analysis that would be best suited for the original tribunal to make. And that is first and foremost, as best we can, we have this number of people that we've tried to identify. Is this particular defendant, Mr. Billings, within that class? And then if so, the answer is simple, terminate. However, under Rule 60, I think part of the problem the defense has is that under Rule 60b-6, there is authority for the court in the interest of justice in revisiting, and that's where the jurisdiction comes from, where this court has looked at Rule 60b-6 and determined that it gives the right when there's an issue of clarification, when the parties cannot agree on the terms of an order, that the court has the jurisdiction, and that's the word that this court has used, to revisit a prior order for clarification, excuse me. So the state put in process this system of going back before the original tribunal for the clarification on who is and is not within this class based on the group of offenders they tried to identify.
Well, was this a clarification, or was this really a reassessment?
It's a clarification first and foremost, because it's two-pronged. First of all, under Rule 60b-6, the test is two-pronged. One, you have to have extraordinary circumstances. For extraordinary circumstances, the state submits that in a Supreme Court opinion whereby you have an as-applied analysis to a limited group of offenders without any direction is extraordinary. That if this individual in particular is within that class, then it's simple. You have your termination. The thing is that under Rule 60, 60b-6, because that provision is not a catch-all, but a grand reservoir for equitable remedies, that the court on its own, and this court has identified Rule 60b-6 as having given the court the authority not only to vacate, but also to modify judgments, and having the authority to do either with the jurisdiction to clarify. The state was just asking the court to clarify. Now, there was a discussion between the ADA as well as the judge at the hearing, where the judge said, you know, what is my authority here? And the ADA said, well, Your Honor, you need to make your own independent inquiry. However, we do think, based on your independent inquiry, you know, you can do these other things. So in other words, the state wasn't asking, did not move the court. And that's important. The language is move the court, which this court has determined does not have to be in writing. The state moved the court for a review hearing. The best practices memorandum says review hearing.
When did the ADA move the court for a review hearing?
The ADA at calendar moved the court to hear the matter for the purpose of clarifying, for addressing the issue regarding Grady 3.
I don't see, because I can't find anywhere where the ADA actually said the word 60B, said the word
that is correct,
said the word move, said. You see where I'm coming from? And
yes, I did.
Correct me if I'm wrong.
No, you're absolutely right. The ADA didn't say the magic words. 60B did not say the magic words move, but the ADA did present the matter to the court for the purpose of determining whether or not this individual was within that class. And I think what's most important is the defendant's understanding of why he was there. At the very end, when he appeals, he says, but Judge, I thought Grady said I should be terminated. He understood he was there for deciding the issue of whether or not to terminate him. He thought he was within the class of Grady and that the court would agree that that meant he would be terminated. That was the purpose of bringing it forward. That was the purpose that is clarified by the best practices memorandum that is in the court file.
Ms. Callaway-Durham, I mean, isn't it kind of the problem that since there was no motion. I mean, whether there would be appropriate to have a motion in the cause or Rule 60B motion or whatever kind of motion, there wasn't one. There was no formal notice of the hearing. It was just simply calendared and presented before a judge. And of course, even based upon, even if Mr. Billings had read the memorandum, which I doubt, but even if he had read the memorandum about termination of satellite-based monitoring, he would sort of reasonably be thinking, I'm in the Grady class, I'm going to go in here and it's going to be terminated. Not, we're going to have a new determination of this and I'm going to have satellite-based monitoring imposed on a different ground. I mean, isn't that sort of, you know, we you know, doing a due process, there was just no process here at all. I mean, that I've been able to find.
The state would disagree because first and foremost, this court has already said that a Rule 60B motion can be made orally. It does not have to be made
I
in
understand,
writing.
but I mean, with the defendant here, you know, he's being called in, he thinks to have this removed based on Grady, and it turns out you're having a hearing on another topic.
Well, had he fallen within Grady, that would have been the end of it, and that was the problem because the state, part of the reason the state put this process in motion is because it was not clear who, including whether or not Mr. Billings was within the class. The state would disagree that it's not, that it was clear that he was within that class.
Right, but the state recognized that this is one of those people that is in, that we do have this confusion over.
Yes,
and
absolutely. There was confusion.
So, you know, again, I'm a little baffled with just putting something on a calendar.
Well, again, it had the court on its own inquiry in clarifying whether or not that order placed this particular defendant within the class of Grady 3, he would have been terminated. Based on the court's findings of fact, based on the competent evidence that was heard and presented, based on...
Well, I'm sorry, I'm jumping ahead here, but speaking of evidence, I don't recall any evidence here at all.
The evidence, a Rule 60B motion, and in fact, Grady 3 uses similar language. It says, in reviewing a trial court order, and this is the same language whether it be 60B or not, we are strictly limited to determining whether or not the trial court's judges' underlying findings of fact are supported by competent evidence and whether those factual findings in turn support the judge's ultimate conclusions of law. And having done so, there were 3 sets of competent evidence in this case. One being the static 99. This court in Overton has already determined that when a defendant is at the highest rating possible, that in and of itself is competent evidence without any other findings. The second set of competent evidence is the admissions of the defendant. That is long held to be competent evidence.
What admissions of defendant are we talking about?
Okay, first of all, the court, and we're not saying this is evidence, the ADA made argument about the underlying circumstances involving the defendant's prior crimes. After making those arguments...
Now, haven't the cases clearly said that monitoring can only be imposed based upon the elements of the crime and not
that is for
get into the underlying?
No, ma'am, that is for determining whether or not they are in the aggravated class and determining whether or not there's a basis for SBM, whether or not the court actually grants SBM. The court in State versus Green made that very clear, Green without an E, which was cited by the state, that you can look to the underlying factors in assessing the risk for that particular defendant. That argument is made again and again, but that was about whether or not you look to the elements of crime and determining whether or not it was an aggravated offense.
Is that the evidence from the original trial? Or I mean, what evidence are we talking about here?
No, the evidence at the SBM hearing, which more often than not is done in conjunction with a plea.
Wasn't there only argument?
I'm sorry?
Wasn't there just argument from the state?
Right. And following the argument in this case about the underlying facts, the court then heard from the defendant. The defendant then made admissions, which are competent evidence. In his admissions, the ADA had already argued about the 2 sets, not convictions, but sets of convictions for indecent liberties in this case. The state argued about one being the school children, wherein this defendant was seen acting strangely and then masturbating, not once, but I believe a couple different times. the people on the field trip, the adults had to move the children from one place to another, trying to get them away from the defendant who followed them around masturbating. And then he was, the police were called, he ended up being convicted. The second set of offenses being that he was at a public lake with his girlfriend's 11-year-old daughter playing in the water, then began fondling the private parts, the vaginal area and breast of two other little girls' siblings who ran and told their father what happened. Then there was a work release incident while he was in prison on the indecent liberties. He then, while working on work release, placed a box cutter to the knife of another employee and said he just wanted to talk. He was then convicted of assault with a deadly weapon.
Excuse me.
I'm sorry.
Excuse me. I mean, it's clear that the defendant's record in this case is horrific.
Yeah, absolutely.
That's clear.
We
But
got that.
I didn't see any evidence of the state presented any evidence of the efficacy of satellite-based monitoring.
Okay. Well, that's the thing. This is not a Grady hearing. Well, let me get back to the defendant's admissions, and then I'll answer your question about the efficacy. But as far as his admission, sorry.
Before you go there, I want to ask a question. On page 35 of the record and 27 of the record, that's the memorandum from the Conference of DAs. Along page 28 is the best practices.
35, I see, is 28.
Yeah,
in the
20, 27, 28, and then on 35,
Okay.
they list the folks who might be subject to a Grady, and at the top of page 35, it says SBM ruling offender letters. And Mr. Billings is listed there.
Yes, that's correct. He was sent notice not only by the Department of Public Safety, but he was also sent notice by the ADAs. It wasn't just that they placed him on a calendar. He received notice not once, but twice.
I wanted to clarify that he was on monitoring and out. He just didn't show up on his own.
No.
He absolutely knew that he was supposed to be there that day.
That is correct. That's why he appeared. That is correct.
So there was notice given to him, just apart from the calendar notice.
Yes.
As is shown in page 35 of the record.
That is accurate. Yes.
All right, let's go on from there. During the hearing itself, as far as new evidence, was there a new static 99 done on the defendant?
They did he showed up prior to, and I believe that's on the record too, he showed up prior to the hearing where they did another assessment, at which time he ranked beyond the 6 points that was necessary for the highest rating.
And that is new evidence, correct?
Correct. That is new evidence. So that was one. His admission was 2.
Right. And when you go on over, when I'm looking at the record, he testifies, the court, it looks like he, from page 46 of the record over to page 50, Mr. Billings gave extensive testimony in court.
That is exactly accurate. Yes, that's my point. The state's point.
I want to clarify 3 things. There was notice, prior notice. There was new evidence, and the defendant did extensively testify at the hearing.
Yes, that's correct.
Okay, and is there any dispute about that?
We don't have any dispute about that. It's in the record.
Okay, I just wanted to clarify that because there's no need going down presumptions and what ifs if we have evidence on the record to support the position that he had notice, that there was new evidence, and he was given a opportunity to testify.
Yes, that's accurate.
Well, I understand this when you talk to the court, but he was not actually, and this may be a distinction that doesn't make a difference here, but he was not testifying. He was basically making his own argument on his own behalf. I don't believe he was sworn in to testify.
I think that is a semantic that the state.
Right, like I said, it may not make a difference, but when we say there was no testimony, there was no testimony.
Evidence is what's relevant, Your Honor, and competent evidence is definitely defined as what a reasonable mind might accept is adequate to support a finding.
Right,
What's necessary.
I understand. I just want to clarify. We said no testimony, no sworn testimony in the sense that we normally think of testimony.
Well, was there a new reportable conviction? that would trigger a new satellite-based monitoring hearing?
This was not a new satellite-based monitoring hearing. At no point on that in the record do you see the words Grady hearing. This was a review hearing solely for clarifying the lack of procedural direction from the opinion from the satellite-based monitoring statutes in order to comply with the mandates of Grady 3. And that being first and foremost, was he within the class, which would make him automatically terminated? The court under the, I'm sorry.
Ms. Durham, I want to clarify one thing. Going back to this list of offenders that may be affected by the ruling in Grady that were identified by the Department of Public Safety, and they all received. Let me ask you this. In addressing the defendant's argument, if the court does not have jurisdiction to address these issues, then they wouldn't even have jurisdiction to bring the defendant back to terminate.
That is exactly the point, Your Honor. That's exactly the point. The fact that the court had the authority over and beyond that with its inquiry, because he clearly, based on the fact that he relied in its findings of fact on the indecent liberties convictions and on the static 99. Static 99 is not relevant. State versus Davison, this court has already found that the only time that static 99 is even relevant is if you're within that fourth prong, which is where you have committed an offense involving the physical, mental, or sexual abuse of a minor. And that indecent liberties is, in fact, by definition, according to this court, one of those offenses. And having done so, that brought the static 99 into relevance, not only as competent evidence, but for purposes of a reason outside of just recidivism, such that Grady 3, is not applicable in terms of this particular defendant getting termination. Grady 3 was all about a meaningful opportunity.
And Mr. I'm going to clarify again, the static 99R that appears at page 54 of the record, that was a new assessment.
Correct.
That was presented and introduced to the court. Is that correct?
That is correct. That was
done prior to this hearing that we're hearing today.
It was done at the hearing. It's on the record where Officer Hines handed that up.
Thank you.
And having done so, that placed him outside of Grady 3. Because he was outside of Grady 3, what the court did was give him what Grady 3 talked about was a meaningful opportunity for termination. The problem is that after giving him that opportunity and listening to him speak through what we would argue is competent evidence, the court, and also looking at a third set of competent evidence, which was the court file, the transcript is clear on page 12 that the court took copious amount of attention to look at the fact of what convictions he had, the dates of those convictions, the number of those convictions, what they were for, trying to make sense of it all. And that in doing so, it was looking at the shuck. The shuck, and having done so, is in and of itself competent evidence. That's State versus Adams. The contents of a file are prima facie evidence of facts therein. Gibson versus Gordon, the only evidence to prove what's in the file is the contents itself. State versus Mitchell, the record speaks for itself. So when you're looking at the new static 99, when you're looking at his pages of transcripts of his admissions to everything that the state argued, whereby he never denied any of it. In fact, what he said was that he pled guilty to all of it in order to get out of jail, and that he never denied that anything the state said wasn't true. The court, looking at those three things, made findings of fact orally and written. It made findings of fact that orally as to his age, when he said that he had been chemically castrated, which I won't belabor the point that the state made as to why that would not matter for indecent liberties. But the court immediately asked him, "You're 49, correct?" And he agreed. The court file makes clear when his date of birth is, and the court made a finding that based on his age at release, which the court file would show he would have been 38, that based on him having at least 2 sets of prior convictions for indecent liberties with children, what he said with 9 different conviction dates, that was the court's language. He's looking at the court file, which again is competent evidence, and also the admissions of the defendant. That he had I'm sorry?
How do you distinguish this court's opinion in Clayton?
Off the top of my head, I would have to go back to the defendant's brief in Clayton. I cannot recall. If Your Honor want to ask me a more specific, wants to ask me a more specific question.
Okay, it's a case authored by Chief Judge Stroud regarding jurisdiction and the lack of another reportable conviction before you can have another hearing. It's in this case, in the Clayton case, the defendant had already had a satellite-based monitoring hearing, and then the state went back for a reassessment without a new reportable conviction, and this court held that there was no jurisdiction to do that.
There was no jurisdiction to have a new Grady hearing. This was not a Grady hearing. Under Rule 60B6, as interpreted by this court, the court has the authority. The exact language is that where the parties are unable to agree about the terms of a prior order. In this case, the Static 99 from 2009, excuse me, not Static 99, the AOC 616 from 2009 only gave that judge the authority to check one box. It did not mean that that defendant did not fit into one or more categories. He was just limited to checking one box. So on its face, it was not clear whether or not he was within the Grady classification. So in seeking clarification on that issue under Rule 60B6, this court has already held that the court has jurisdiction under Rule 60B6 to revisit a matter when it is not clear. That's Ammons versus Goodyear. When the parties cannot agree on the terms, the court has the jurisdiction to revisit, to clarify an issue. And so because we're not talking about a Grady hearing, that would mean that Clayton is not on all fours with this case, because it is not a Grady hearing. It is a review hearing to revisit under the extraordinary circumstances posed by the Grady 3 opinion in conjunction with the cause shown, which is the second prong, and that is Harris versus Carroll. I'm sorry, there are three Harrises here, three H's. Under the test, excuse me, for whether or not a case fits within the 60B60, showing that relief, that justice demands relief. Justice demanded relief if he fit within Grady 3. The problem is he did not, because of the indecent liberties ground for which the Static 99 makes clear. And because Rule 60B6 is not a catch-all, it is a grand reservoir of equitable distribution.
Ms. Calley-Durham, since we're getting close on time, I just want to go back to Zachary's question about evidence regarding efficacy. This is
yes, I'm sorry.
Repeatedly in cases, over and over and over, we see these cases where the state has simply presented no evidence. What's up with that?
Okay, for a 60B6 hearing to revisit under the extraordinary circumstances of Grady 3 and the cause shown that justice required doing so for the clarification of whether or not this defendant was within the class, it also allowed the court to do as justice required.
Let's assume that the United States Supreme Court's opinion, which says that the reasonableness has to be looked at, and part of that is in fact the efficacy of the program, whether it's called a Grady hearing or whether it's some variant of a Grady hearing, or if it's some other type of hearing that was made necessary because of a Grady, if the Constitution still applies, which let's assume it does. So you're saying that in this instance, there needs to be no evidence of efficacy, although the United States Supreme Court has directed us in other contexts we do.
The United States Supreme Court directed for Grady hearings, and that's where the term Grady came from, was Grady 1, right, that you have a reasonableness inquiry where an issue is the initial placement into SBM, which is what triggers that SBM statute. This was not about the SBM statute. This was about a review hearing under 1A-1 Rule 60B6, where you look at the competent evidence, the findings of
Right,
fact, the
but for
conclusions of law.
satellite-based monitoring, the cases have held that this inquiry has to be done.
That is
Saying
for
in this instance, it doesn't have to be done.
this is not an SBM hearing, this is a review hearing. There is no
Okay.
caveat under under NCGS 1A Rule 60B6 that says SBM doesn't apply. This is a review hearing like any other civil matter for which there is an issue for clarification. The issue for clarification is he within the class? And under Rule 60B6, vast authority.
You go ahead and finish. We're asking you a
Under-
lot of questions, so we'll let you go ahead and finish.
Under Rule 60B60's vast authority, under the the grand reservoir, whether or not based on that independent inquiry, the conclusion of law is not whether or not it was reasonable as it would be in the initial Grady hearing. The conclusion of law is whether or not there was a reasoned decision such that is in the interest of justice to have maintained SBM. The reasoned decision being the findings of fact, based upon the findings of fact that the court made based on the competent evidence that was presented.
Under that theory, then the state could simply put back on the calendar all the people who are under satellite-based monitoring, and it might be subject to a problem constitutionally, and we'll just say, well, that was a review, we're no longer doing a SBM determination?
No, Your Honor, we're not. The purpose was the extraordinary circumstances of Grade 3 in that limited class.
Well, I understand in this particular instance,
Yes.
but what happens to cases is they get applied to other situations, right?
You still have to have the two-pronged showing for 60B60. Without the extraordinary circumstances, you don't get there. And Grady 3 is the extraordinary circumstance. And there was no other way to remove him had he fit within the classification, but by doing exactly what the state did. Again, the point of the motion was not to appeal. The state did not appeal Grady 3. It was not a motion to dismiss. It was not to amend. It was not to overrule the 2009 order. It was not to benefit the state. It was not a Grady hearing. With all that in mind, it was to try to implement, upon clarification from the court, what Grady 3 intended, which was also a meaningful opportunity for review. This goes to the defendant's benefit as well as the state, but it wasn't about the state. It was about implementing a directive for which procedures were not in place, and the only authority out there was statutory, that being Chapter 1A-1, Rule 60B60.
What would the state have the court to do, please? We're well over time.
Okay, the state would ask that the court deny the appeal on the basis that all of the reasons given are outside of what he appealed based on. He appealed saying, Judge, Grady should have terminated me, meaning in layman's terms, he thought he was within the class, which was the point of the hearing in the first place. All of the basis for appeal, the jurisdiction, the evidentiary standard, which again would not apply at the review hearing. This is not an analysis under Grady for purposes of placement into SBM, whether or not he had counsel, whether or not it's a period of time versus a term of years. None of that is what he appealed based on, and the court can't create appeal. He doesn't have a right to appeal those other factors. We would ask that this court dismiss the appeal, or in the alternative, not grant the petition, or because of all the confusion, that the court remanded with directions for how to procedurally handle determining whether or not an offender is within the classification to avoid further future confusion, since neither the Grady 3 opinion nor the SBM statutes speak to that. Although we do believe Rule 60B6 and or motion in the cause might be the appropriate vehicle.
I have one quick question.
One more.
Sorry.
Okay.
Do you concede that the 2020 satellite-based monitoring order supersedes the 2009 satellite-based monitoring order?
We, in that it was a motion to revisit and to clarify, Rule 60BC allows vacations and or modifications. So in that context, yes.
Okay, Thank you.
Okay. All right, Mr. Grant.
Thank you, Chief Judge Stroud. I'd like to make a few points here in what little time I have left. There is nothing ambiguous about the 2009 order in terms of Mr. Billings falling within the Grady class. The order notes that he is a recidivist. None of the other qualification boxes are checked. A judge found in 2009, in essence, that he is not an did not commit an aggravated offense or was subject to another lifetime category, and failed to check the box that said that he was convicted of an offense involving the physical, mental, or sexual abuse of a child. There's nothing ambiguous about this order. There was nothing that needed clarification. What the state is trying to do is get a second bite at the apple. Now, we've had an interesting discussion about whether in the abstract Rule 60B or some other motion provides the state or defendant to seek reconsideration. And I think at this point, I'm willing to concede that in some case, there may be that may be appropriate. Again, the state did not make a motion in this case. The state and the Conference of District Attorneys and the Attorney General's office doesn't get to make the law in this state. This court and our Supreme Court and trial courts do, and the General Assembly does.
Mr. Grant, I think our legislature does make the laws, right?
Yes. You are very correct, Judge Tyson. The legislature makes the laws. This court says what the law is, as is emphatically its duty.
Could you address the 3 points I raised earlier with the state? That is, your client's name appears on the list that was identified that said he got a letter. And he was obviously in court that day based upon, I don't think he just showed up there. He obviously was there, and by his testimony, he was prepared to address the issue. So that tells me he did have prior notice to be there. So I want you to address that based on page 35 in the record. And I want you to also address whether or not the static 99R that was done, whether or not that would have been new evidence at that hearing as well.
So I think we can assume by virtue of the fact that he was at the hearing that he received some notice, and we're really not quibbling with whether or not he received notice. I mean, all we said is that he didn't receive the form notice that generally goes out in these cases. Obviously, he knew he had to be there. As for the static 99,
he was also prepared to speak on the issue too, because he did that, right?
Yeah, and I want to clarify on that point, Judge Tyson, that is not evidence. I mean, the man was denied the lawyer he was rightfully entitled to and was basically making his own arguments. Last time I checked, testimony, sworn testimony, and formal stipulations and exhibits constitute evidence. So to your point about the static 99R, yes, I think that is a form of new evidence that was introduced at this hearing.
Your client also admitted that he was working. That's in the record as well, that he was employed and working, which would tend to negate any presumption of innocency, right?
I mean, perhaps. I think there are plenty of working people in this state that are nonetheless indigent for the purposes of obtaining counsel.
Well, he made no claim of innocency. He did affirmatively state he was working, and there's nothing in the record to say that he was denied the opportunity to retain his own counsel or to ask for counsel, correct?
I mean, the record is what it is. The issue of counsel is simply not discussed at the hearing, and I can't really speculate as to why it wasn't.
But the record does reflect your client was working.
I believe so, yes, Your Honor. With respect to the static 99, it brings me to a very fundamental thing that was discussed very little in the state's argument, which is Green and State versus Blue and State versus Morris, Green with an E, is settled law. Let's assume that we can have one of these rehearings, and let's assume the state can get a second bite at the apple. Well, the state, having got its second bite at the apple, utterly failed to comply with Green and its progeny. It just simply presented no evidence of efficacy, no evidence of the nature of the program. You can introduce 10 static 99s at this hearing showing that Mr. Billings is purportedly a high risk to recidivate, and that does not meet the state's burden. So, in fact, I'd say the static 99 is the only piece of evidence the state did present at the hearing, and that, as we know from the cases, is simply inadequate. So this court
did review the court file and the nature of your client's convictions as well. The record does show that as well, correct?
Yes, but that is also inadequate. I mean, State versus Green, they had a clerk from the clerk's office in that case come and testify about in great detail about the prior convictions of Mr. Green. And this court said unanimously that it was insufficient because it doesn't address the fundamental issue that is going on in all of these cases, regardless of whatever weird procedural posture they're in, which is this a Fourth Amendment search that is reasonable? And the state continues to fail time and time and again, as it has in this case, to present the necessary evidence for a court to make that conclusion one way or another. And so unless there are additional questions from the panel, I would simply ask that, given that Mr. Billings remains subject to an unconstitutional search by virtue of the state's failure to remove him from SBM and its insistence on conducting this ad hoc hearing before a court lacking jurisdiction, at which it totally failed to meet its well-established burden, and where the trial court both exceeded its statutory authority and denied him his right to counsel, we would ask that this court reverse and remand the orders at issue and clarify that there is no operative order placing on Mr. Billings on SBM going forward.
All right. Any other questions? All right. Well, thank y'all very much for your arguments, giving us a lot to think about and work on. We appreciate it very much.
Thank you, Your Honor.
All right, and we will adjourn.
Thank you.
This session of the North Carolina Court of Appeals is now adjourned.
Great job.
Thank you for letting us go over.
Thank you, Judge.
Thank you very much.
Thank you.